Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate and trust administration. To keep up with all things digital, please subscribe to iTunes, Stitcher, Google Play, Spotify, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbard LLC, Ross Brook, a principal at Estate Genie, and Justin Brown, a partner at Ballard Spahr LLP, with today's topic.
Welcome to the Digital Planning Podcast. I am Justin, and I'm here with my co-hosts Jen and Ross, and we are very honored to have somebody here today who I know well from my firm. We have Greg Szewczyk, who is a partner in Ballard Spahr's Denver and Boulder offices. And Greg practices in the area of privacy and data security, and he is the practice group leader for our privacy and data security group here at Ballard Spahr. Greg helps companies of all sizes, including Fortune 500s to startups, to help build and maintain their privacy and data security programs. He advises hundreds of companies on various compliance issues, from the use of artificial intelligence to vendor management to routine data processing matters that all arise in our day-to-day businesses. Greg, thanks for being on the Digital Planning Podcast.
Thanks for having me, Justin, Ross, and Jen. It's great to be here.
So first thing, Greg, how did you get into privacy law?
So, I actually started my career as a general litigator at a different firm in New York. And when I moved over to Ballard, I started just also as a trial litigator. And that was back around 2013. Around that time, as the firm was starting to grow, it's at that time more cybersecurity as opposed to just purely privacy capacities. We didn't have much out in the West, and it was a growing field. And I kind of just raised my hand because it sounded like an interesting field. It became pretty clear that although cybersecurity and incident response was hot and interesting, data usage was really going to be a growing field. And it was just something that really caught my eye, and I wanted to be involved in it. And my practice just started shifting pretty quickly. And within just a few years, I was fully in this field and completely immersed in it. And we saw Cambridge Analytica just a few years later. And since then, it's just been an exploding scene where we saw the first state privacy law pass, and then a dozen more, and now we're up to 20. So, it's been something that's kind of been hard to not be a part of, whether it's from a legal perspective or more from a day-to-day thing.
How do privacy laws vary from state to state? Because my understanding is that different states, you just mentioned there's 20 some odd states that have privacy laws, but I'm assuming they're not all the same. How do they vary from state to state?
So, you have both the kind of the global level, and then you get down to, really the details. And at a global level, you have somewhat of the misperception that California is the strictest, which in some ways it is, but it isn't in all ways. All privacy laws kind of take the same general approach of a series of rights that are provided to individuals about what kind of rights they have over their data, and a series of obligations that are imposed on subject businesses or organizations that are subject to these laws. But then once you get past that, you start seeing that there are some very, very important differences amongst the states. And starting with what organizations are subject. At the U.S. level, there are applicability thresholds for all of these states. Some states have them apply based on the size of the entity. Some states have applicability thresholds that are only based on the volume of personal data that you're collecting from the individuals within their state. You also have differences in what types of organizations are subject. Some apply to nonprofits. Some don't apply to nonprofits. Some have carve-outs at the entity level for, say, financial institutions. Some have exemptions related to the entire entity that is subject to the federal regulations, such as the GLBA for financial institutions. They're fully exempt from a state privacy law, whereas other states only exempt the data that's subject to the GLBA. And so you have this very patchwork state by state, where it is very difficult to figure out which state is necessarily the strictest for each one. And that's something that we've just seen grow over the past several years and will continue to grow unless and until we have a preemptive federal law.
Do any states have a private right of action for individuals to bring claims for privacy violations, or are there other nuanced laws along those lines?
So right now, no general comprehensive state privacy law has a private right of action for a privacy violation. California's law does have a private right of action related to data breaches. It was kind of slipped into the privacy law when it was passed. So that's a nuance there. But we do have more nuanced privacy laws, some of which do have private rights of action. When I say nuanced laws, I mean Illinois has a biometric identifier law. So it specifically relates to the collection of biometric identifiers. So, think fingerprints, think facial scans, but also think about things like facial geometry that's used for creating avatars or voice templates that might be collected by things like smart headsets or transcription services. So things that are powered by AI can frequently collect types of biometric identifiers. That law has a private right of action in it if you don't collect the correct types of consents. And we see a very active plaintiffs bar on that. And so in addition to these 20 state privacy laws we're talking about, we also see these more nuanced laws popping up. And those more often tend to have private rights of action.
And with respect to U.S. state privacy laws, how are they different than the GDPR, or how do they intersect?
So, kind of at their core framework, they're built along the same general structure of, these rights and these obligations. But the biggest difference, just at a very high level, is in many ways the GDPR is built on an opt-in regime where companies have to obtain consent for the use of data in a lot of different situations. Whereas in the US, it's often built in a notice and opt-out regime. And that's really, really high level generalization. But in a lot of ways, that is how it is set. I mean, there are exceptions. There are some states that are shifting that paradigm a little bit. But at its core, that's how I tend to describe the difference.
So, Greg, as an estate planning attorney, what are some issues that I should be aware of for my clients with regard to the protection of their privacy rights or the safeguarding of their data?
Well, I think there's a few things that I'd want to make sure that they're aware of. And I'd separate that question into two. One is privacy issues, and the other is safeguarding their data. On the privacy front, we have been talking so far about state privacy compliance. But what we have also seen coming up lately, especially in the last few years, is in addition to these state privacy laws, whether it's comprehensive or whether it is more nuanced, is we've seen a cottage industry of plaintiffs' attorneys seeking out older laws that have private rights of action and finding class actions or bringing together a lot of arbitrations and demands. And I'm talking about laws like wiretap laws and other things like that. And just bringing we've seen hundreds to thousands of these filed in the last few years, often related to things like website analytics. And so when I think of the estate planning field, and this is where I'd actually welcome kind of your input, but we see a lot of these lawsuits filed against fintechs and other financial tools that I could see be used in the estate planning world, where, say, a common session replay tool, so the type of website analytic that's used to let you see where somebody is clicking on a website or on a field, that might be used on a platform that's used to help figure out different types of financial planning or something along those lines. If that is being used on this website, we've seen plaintiffs' attorneys argue that that is actually violating this older wiretap law because it's sharing with the website analytic provider that information and allowing them to wiretap or eavesdrop in on that. So it might be something that is not really being thought of when you're purchasing that type of a tool or purchasing a platform, scanning what types of session replay are they using, what types of pixels or cookies are they using on that. But due to the nature of the information that might be collected, it might be a higher risk target for this type of litigation.
Yeah, and I think the issue that I frequently run into with clients is they're not thinking necessarily about their privacy rights when they're coming to me to talk about their estate planning, or thinking about how some of their information could be out in the public domain and being used and taken without their knowledge, right? So a lot of the times they're not thinking about what steps do they need to do to protect their privacy rights, such as if you're posting something on LinkedIn or Facebook or Meta, right? Like you've got private information on there, and whether it's your biometric information or you're voluntarily posting private information, right? People aren't thinking about that. Or we talked on another episode about smartwatches that are gathering health information, and that's private information. But are you giving up some of those privacy rights by wearing these smart devices, for example?
Yes, and to piggyback on what Justin just said, the rise of smart houses and the technology that is integrated into the whole house system that, essentially everything is being recorded, on some level. And where does that information get stored and saved? I think a lot of people don't even realize that in most states, a will does become a public document when it is admitted to probate. And so one way to help with privacy related concerns is to use revocable trust agreements and have the will, be a pour over will that pours everything in the estate over into the revocable trust, and not have, asset or other type of beneficiary information included, in a will that will be ultimately subject to public disclosure.
Or it could be just as simple as don't put your children's social security number in your will so that they become public to everyone once your will is probated, right? It's little things like that.
Clients that are coming to, law firms to help with their planning, those concerns are dealt with during the planning process, but we're also seeing a lot of startups that are allowing people to essentially do their own estate planning and create their own wills, and they may not have those types of safeguards or that knowledge in place. So it can be dangerous.
So Greg, how does digital privacy come into play when we're planning for digital assets or online accounts?
So a lot of it's going to depend on the type of the digital asset and what kind of regulatory front you're looking at there. If you're in a regulated industry, there's often some very specific regulations on what types of sharing can be done with certain types of account information. If you're dealing with certain types of regulated financial accounts that are digital assets, there are very specific regulations both at the federal level and under some certain state financial regulations as to what institutions can share and what can go out and how that can be done. There has been some change on that regulatory front, although that's still a few years away, including how third parties can pull that information and the technical ways that can be done. That moves all the way over when you start talking about other kinds of digital assets, such as crypto, NFTs, and other things, where it can still be a bit of the Wild West. And when it gets to that, it gets back to the point a little bit that Jen was making and that you were making, Justin, about being careful about what you are sharing publicly and how you plan about that, what can get out in the public realm. Because any information that you may be able to put out there or information that can be derived from what is put out there can put some of the security of your accounts at risk. So, how you are thinking about your digital privacy is really important. And that also goes into, what we are seeing. You mentioned, Justin, what people are putting on social media accounts. What can be used to social engineer an attack on an individual? There are tools that are now being used that are powered by AI to scrub social media accounts for more common everyday people for targeted attacks used to social engineer based on what they have been posting and including on, what kind of digital accounts and what kind of digital assets they have to specifically look into that. So it all goes into, a more making sure everybody has a cultural and cybersecurity and privacy awareness, not just for, what we used to say for kind of like a corporate culture, but almost like a personal culture for everybody.
I think that's a good point, Greg, because I frequently see people posting things on social media, whether it's their kids, whether it's their family members, and just the voluntary giving up of their rights that they don't necessarily recognize when they're posting pictures of their 10-year-old child, right? Or even, Jen, I don't know if you see this in the prenuptial agreement realm, where people are considering whether or not to place restrictions on what you can post on social media with kids or future kids or in a relationship, right? I think we're seeing that more on the estate planning side because of this increased concern about giving up people's rights and inadvertently giving up people's rights.
So I have begun to see that creep into prenuptial agreements or considerations for future children that aren't even in existence. But I often see on social media feeds, personal or embarrassing photos of children posted by their parents that, make me think, depending on the level, if there could be some future cause of action by a child against their parents, for posting that type of content, that lives in infinity on the internet. I know there's a lot of other, legal considerations around those types of topics, but it is definitely something to think about, as the regulations and potential future laws, get developed nationally in this area. In connection with sharing estate planning documents, with family members or fiduciaries, do you have any advice for minimizing or protecting privacy considerations in that situation?
I think, one consideration is always, what's the method of transmission? If there's going to be sensitive information involved in any documents that's being shared, what's the method of transmission? We generally always recommend try to avoid sharing information, like sensitive information, through emails, as attachments to emails. When we're dealing with family members, I know that that's often a way that people like to share documents, but we also know that emails are one of the least safe and secure methods, especially when it comes to individuals. How many people do you know who have had their emails compromised? And when somebody has had their email compromised, we know that threat actors are often looking through email history and seeing what documents have had attachments, looking for sensitive information. So, that's one thing that we often try to advise, is make sure that you're thinking about how you're just transmitting documents with sensitive information around. And that applies equally in the estate planning context as it would in any others. But, this is an area where I actually would love to hear your guys' thoughts as well about, what are some context-specific considerations that you often see come up.
Well, I think one of the things that we try to impress upon the people who work in our group is, just as you said, Greg, the sensitive nature of the information that we are in possession of and the method in which we transmit it. I had always learned that sending things through email is like sending a postcard through the U.S. mail, right? If somebody flips over the postcard, they can see your message. And if somebody's going to hack into your email, they can see all the information. So we try to send everything securely and through secure encrypted email. And when it comes to receiving documents from clients, we put them in we have them upload them onto a secure site that we can then get into later on. So we try to take it seriously. The hardest part, I think, is when clients are not, it's not on their radar screen. Like the privacy and the security concerns are not on their radar, and they will just send us documents via email without any concern whatsoever. Jen, what do you do?
We take security and privacy very seriously as well. And I will often have clients, although they've been provided with a secure upload link to send us back information, they are sending us financials, even, questionnaires that may have a social security number included in just a regular attachment in an email. When we send out documents, we do send them, securely or through different share files. And a lot of those types of share links will expire, after a certain period of time. And so if they don't download the documents, they'll have to come back to us to have another link sent. And I do see clients, a couple years after the plan, they went to go to the link and the link is no longer valid. And they're asking if we can send PDFs of the documents and emails because they want to be able to have it, in that manner and not have an expiring link. And for whatever reason, they don't want to have it downloaded somewhere else. So in those situations, we'll look at it on a case by case basis, but it's definitely not the preferred method. But I do get that request even with educating clients, about the issues.
So let's say there's a breach at some point, whether it's on the attorney side or the advisor side or just the individual. What can somebody do if their private information has been stolen?
First of all, take advantage of the resources that are given to you. I mean, if you're an individual and you receive a notice of breach, take advantage of the credit monitoring, of freezing your accounts. There's going to be information in those notices. I know most people just throw that out with the rest of the mail that seems like junk mail, but actually open it and take advantage of it. Because there are things you can do to protect yourself. And a lot of that information in there is good. So, that's step number one is actually take advantage of the free resources that you're given. Because you're going to get at least 1 year of credit monitoring almost from every single one of these. Even though it's not always required by law, it's just pretty standard to have that come through. So that's what I say is make sure that you do put that freeze on your credit. Make sure that you do take advantage of the credit monitoring services that you have. So that's really important for individuals to do, because a lot of these services will also come with some kind of like web monitoring services to see what's going on. Also, you need to be diligent about paying attention to your accounts. Make sure that there isn't suspicious activity going on, because the reality is if a threat actor has taken or sold your financial account information or your social security number, there might be attempts to have fraudulent account activity going on, and you need to be paying extra attention to make sure that you can take the appropriate steps to avoid having some kind of financial consequences for it.
Do you think there are any, best practices for storing estate planning documents securely, both digitally and physically?
From a digital standpoint, making sure that you are storing any data with strong encryption is absolutely essential. Using any kind of a platform that will allow you to have multi-factor authentication is another one, and making sure that you're using strong passwords. You don't want to be using easy passwords that are related to easily guessable. You don't want to be using welcome. These are things that are, hopefully everybody knows these days, but they shouldn't be passwords related to your family members, your birthday. They should be difficult passwords. People, I recommend that people should be looking up what it means to have a strong password and take some steps to do that.
Do you have any recommendations for frequency on which people should change passwords, absent a breach, of course?
It depends a bit. I mean, so we change the guidance somewhat, especially when it comes to, we typically counsel corporate clients, and it's going to change somewhat. With individuals, there's always the bit of the struggle for how often you should change based on, are you going to be compromising how strong your passwords are with too frequent of changes based on the individual and what they're likely to do. A lot of the stronger passwords will involve random words. And so, we often will counsel, change your passwords based on security incidents that are happening. Always change your passwords after that. And also using password lockers now. Those are available tools that are pretty useful. And especially with how connected people are to their phones, where they can use biometric identifiers to tie into that. There's just no need to be using old passwords. Like that is to me is as important as password frequency, is eliminating those old passwords that have been used for years and are almost certainly out there and compromised. And we hear that is just something that is actually very, very poor housekeeping on still.
So, Greg, you mentioned biometric identifiers. What are your thoughts on conventional passwords versus using biometric information as your quote unquote password, right? Because on the one hand, it's much more secure, right? It's unique. You can't forget your biometric identifiers, right? They're always with you. But on the other hand, if there's a data breach, you can't change your fingerprint if there's a data breach, whereas you could change a password. So there's pros and cons. What are your thoughts?
So I think it depends on, you're absolutely right that when it comes to biometric identifiers or any other kind of extremely sensitive personal information, the stakes are raised. I think that there is a lot to be gained by using biometric identifiers, and it needs to be done in a wise manner. Thankfully, a lot of the ways that you can use it, you could have that biometric identifier resting on a local device rather than where it has to rest somewhere where it's more vulnerable. So if you think about using it in connection with a password, the biometric identifier for your face for a phone scan sits on your phone. It doesn't sit necessarily with your phone provider. So it won't sit with Verizon or it won't sit with Apple. It sits on your actual phone itself. And so you're actually in possession with that, and you don't have to have the fear that that's going to be taken over from a threat actor if they hit your phone provider. Same thing with a fingerprint scan on, say, a laptop. That actually sits on the laptop itself rather than with the maker of the laptop. I also think that there's a lot to be gained from having multi-factor authentication, where you use one, say, a biometric identifier, and then in connection with a password, so that you have both the physical attribute in connection with a knowledge attribute, and that you can get a lot more security through that method.
So how do you feel about biometric information that's stored off of your personal device? So what I'm thinking about specifically is Amazon and Whole Foods have these palm readers, right? So you can go into a Whole Foods, and you can pay by palm. And you're using an Amazon device to record your palm signature. So my assumption is that your palm print is someplace stored on the Amazon server somewhere, but it's not on your local device. So where would you draw the line between using biometric identifiers? Would it be okay when it's on your device, but not okay when it's stored with somebody else? Or what are your thoughts?
Well, I think like any other piece of sensitive information, it's a risk. If there is a compromise on the part of the company that's collecting it, you're certainly going to see litigation come out of it. And frequently in data breach litigation, one of the first off the bat arguments that we see at the motion to dismiss is whether or not they're standing to bring it. And in a lot of cases, it's difficult for the plaintiffs to overcome that threshold. I don't think that would be much of an argument in the case of biometric identifiers. So, that's certainly a consideration. It's not to say that it's not worth it in some instances, though. So, like anything else in today's world, sensitive information is out there. There could be benefits to it. It could be a convenience factor. It could be a security factor. And I think each individual has to make their decision on whether or not they think it is worth it to put their personal information out there for that purpose.
So speaking of biometric data and issues, the 23andMe lawsuit is one of the largest lawsuits for a data breach that settled for around $30 million and drove the company into bankruptcy. And now all of the DNA data and information that were collected on millions of individuals are subject to potential sale. Could you please speak a little bit about the 23andMe lawsuit?
Yeah, so we started off the conversation talking about the patchwork of privacy laws and how, we've got 20 states that have laws that have passed, but, which, by the way, not all of them have gone into effect yet, but that we don't have any comprehensive federal privacy law yet. Each of those state laws have the right to delete for individuals of those those states. So, I sit in Colorado. I have a privacy law in effect here. You guys are in Pennsylvania. You don't have a privacy law. I have the right to send a request to subject companies and request that they delete my data. You don't have that right. And so, when a company goes bankrupt and they're about to be sold, generally all of the data, or if in the context of a merger or an acquisition, generally the data gets sold along with it. A lot of times it's not all that controversial, but in the context of 23andMe, when it's genetic data, there's a lot of concerns about that, about how is this data going to be used? How's this data going to, where is it going to go? What's going to happen with this data? What, in the context of genetic data, there's some very clear and obvious concerns there. And since over half of the states do not even have the ability to request, deletion, what's going to happen? And so we've seen this come up on what is an everyday issue for people and very public in the eye. And so, we're seeing that yet another situation where privacy comes up, not just in the legal realm, but also in very much in the public context. And with that, we have seen some calls again for a federal law. It was kicked around in committee again. I don't see it happening again, but we'll see what happens.
So before we wrap up, what trends or changes do you see coming with respect to privacy laws throughout the country? And how do you see that impacting personal planning?
So from the trend perspective with laws, what we have seen is more and more states are going to pass laws. And we also see not just the comprehensive laws, but more of the nuanced privacy laws. So whether it relates to health data in particular, we've seen a lot of more states pass health data laws. We've seen biometric data laws, and we see AI-related laws that impact personal data collection and how it's used to train AI and whether or not it has discriminatory impacts. I think we're going to continue to see those laws pass. We see them pass in red states. We see them pass in blue states. We see the thresholds get smaller and smaller so that they cover more and more people's data. And we see the exemptions get narrower and narrower so that they apply to more and more companies. And I think that that's going to continue to happen. I also think that we have seen in some legislatures toy with the idea. Jen had brought up what rights do people have to maybe bring a lawsuit. We've seen Massachusetts right now has a bill in their legislature where if they pass this law, they would have a privacy law that would have a private right of action for privacy violations as opposed to data breaches. Whether we've seen other states propose these before and they don't get across the finish line, so I don't know that Massachusetts will either. But at some point, some state will probably pass that. So I think that is a trend to keep an eye on. As to how that impacts personal planning, in some ways it's going to impact personal planning the same way it impacts everybody else, which is you're going to be subject to more laws. You need to be cognizant of these laws popping up. You may never have been subject to one of these laws, but the scope for professionals who help with personal planning, the scope of the laws is going to get broader. The applicability thresholds is going to get narrower, and you're going to be subject to laws that you used to not be subject to. And so you have a whole new regulatory front that you weren't aware of. For individuals, you might have rights that you weren't aware of, and that you might want to be aware of, and you might have some kind of assets that you now have that you didn't know about before. And so, it really just kind of changes the landscape for both the professionals involved and for the individuals.
Well, and I think what also happens to that private information after somebody dies, and what rights do other people have to that information, whether it's a person, an heir, a company, what rights do people have to your private information at death?
In the proposed legislation for privacy at a national level, are you seeing any inclusion for post-mortem privacy rights? So the legal representatives of an estate would be able to exercise, certain rights that the decedent would have had during their lifetime. Are you seeing these types of things being included or discussed?
I did not see that in the most recent version, but we've seen various versions be proposed over the years, and none of them have even made it to a floor vote in the House yet or in the Senate. And so, it's something that is very much a living effort. And who knows what the final version would be if we ever get there.
Greg, thanks so much for your time and for sharing your deep knowledge on privacy laws and its impact on estate planning administration. On behalf of Jen, Justin, and myself, until next time, thanks for listening and catch you on the next episode.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate and trust administration. Please subscribe to this podcast and leave us a rating or review on iTunes, Stitcher, Google Play, Spotify, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.